Good evening, everyone, and welcome to the third edition of the Community Action Network Workshop Series. My name is Julia Fish, and I co-host these sessions monthly on the second Wednesday of the month as an interactive space for local community organizations to learn how to expand some of the work they do and learn from each other about ways to get action or accountability. You're encouraged to participate throughout and engage, so please pop any questions in the chat for me to raise, and we will also open the floor for you to ask your questions directly in the last 15 minutes or so. Tonight, we are talking about director accountability in the local government sphere. To unpack what that actually means, I'm joined by my colleague, Advocate Stefanie Fick, the Executive Director of the Accountability Department at OUTA. Stefanie has just co-authored a paper on director delinquency and will tell us a little bit about OUTA's journey towards holding national state-owned entity directors accountable. We also have Micah, a partner at HGB Schindler Attorneys. She specializes in administrative law, municipal law, and property law, particularly in respect of municipal billing disputes and prescription periods of municipal law matters. Micah Gohl was involved in the successfully reported judgment Argent Industrial Investment CC versus the Metropolitan City of Ekurhuleni. Michael will outline how some municipalities work, what kind of regulations and obligations they have in terms of the law, and then we will discuss what you can do when they fail to comply with these obligations. Firstly, though, I'd like to encourage you, our participants, to introduce yourselves in the chat, say which part of the country you're joining us from, and maybe mention a local entity or municipal department you would specifically like us to discuss the workings or issues at. So let's dive right in. Micah, if we could just start with you. Thank you for joining us tonight.
Thank you so much for having me.
You'll also note, participants, apart from the invitation that you received earlier, Micah is a new addition. She's also from the same firm as Chantelle as advertised. Unfortunately, Chantelle couldn't join us tonight due to a personal matter, but I promise you, Micah is more than fit to be able to be dealing with this matter, and we're very lucky to have her. So let's start with a bit of a framework and background into the operations of a municipality. When we talk about local government, how are their directors, like a board or like we see with a public listed company? Is everyone not just a civil servant or municipal employee?
So if you think about a municipality, it's basically just a really big company in and of itself. The government in this case is just going to be the main shareholder of the company, unlike in a normal company where you have various individuals being the shareholders. So you have various boards or councils that sit, you have various stakeholders, very similar to the way that a normal company works, and you have various like I said, stakeholders that you can hold accountable for various things within the municipality. So within a municipality itself, your main stakeholder would probably be the mayor and the executive council that serves below the mayor, which is where the political elements within the municipality comes in. So when we go and vote, you have a certain number of people that get elected to council from various parties, and they then sit on the municipal council, and the municipal council is then the entity that gets to make all of the decisions for the municipality in relation to a budget or what policies get approved and how they get approved and the wording of those policies and bylaws. So they're essentially on a very high level responsible for the running of the municipality. And they also then have the duty to appoint the municipal manager, which is the next big stakeholder within the municipality. And he is essentially, or he or she, whoever the municipal manager is essentially responsible for the entire administration of the municipality. So, and by administration of the municipality, I mean he is responsible for the accounting of the municipality, for the various departments that deliver the services, for the agreements with the MOEs, so the municipal owned entities, which are basically subsidiaries to the municipalities that enable the municipality to deliver services. So I'm just going to use Joburg as an example. In Joburg, we have obviously the city of Johannesburg, which is the overarching municipality, and then you have City Power, which is the service provider for electricity, and they have a service level agreement, or an SLA, with the City of Johannesburg, and that is an MOE, municipal owned entity, and that in and of itself, it has its own structures that are, you know, where powers are delegated, and they'll have their own boards and directors and CEO and CFO. So each of these, you know, elements, basically, or each of the companies within the municipalities are companies in and of themselves. So municipalities are, you know, very legislative creatures. They are run through various laws that regulate them. And one of those laws is just so happens to be the Companies Act. So the same way that the Companies Act is applicable to a normal company, you know, within South Africa, it is also applicable to municipalities. There was actually a judgment against the municipalities by SIPC not too long ago. SIPC is essentially the regulatory body of companies in South Africa, because the municipalities were failing to provide audited statements to SIPC, which is a requirement in terms of the Companies Act. So there's it's just, that's one of the various pieces of legislation that deals with the framework of municipalities. And it's very interesting to think that, you know, it is a government, but essentially it is actually just a really big company with different names for the same thing that you would have in a company within South Africa.
Thanks, Micah. So you specifically mentioned, of course, the municipal manager there, the mayor. They also have their MMCs and different structures. So take us through a little bit about what the governing structure of a municipality actually is, and what legislative frameworks they have to operate under.
Okay, so like I said, the main stakeholder is the mayor, and the mayor is elected from the municipal council. So the council elects the mayor from within their own ranks. And the council is constituted by elected officials that we elect through the elections every 4 years. And they then have, like I said, the municipal manager, who is responsible for the administration, all of the administration of the municipality, irrespective of what area of the municipality you're looking at. You then have the municipal manager then can appoint sub-managers. And that's where the MMCs come in, where he he appoints various stakeholders or various persons to manage certain areas within the municipality on his behalf. But ultimately, he is still responsible for all of the decisions made by those persons. Sorry, I've just completely lost my train of thought. But yeah, so it's sorry, I lost my train of thought there.
So when it comes to like the structures, what actually holds them accountable? So are they answering to like a constitution within a municipality, or are they answering to specific laws?
There's very specific laws that they answer to. So there's various laws within South Africa that are applicable. There's the Municipal Finance Management Act, sorry. You have the Municipal Systems Act, which is probably the most important and overarching piece of legislation in municipal law. You have the Municipal Structures Act, and you have the Municipal Property Rates Act. Each of these deals with different elements within the municipality. The Finance Act is exactly what it sounds like. It very much deals with how and when and where decisions have to be made, and what procedures have to be followed in order for those decisions to be made, in order for finances to be brought into the municipality, and then also for the municipality to be able to spend money. The Municipal Systems Act, the name is a little bit confusing if you think about what it actually does, but it essentially allows for a municipality to govern, and it allows a municipality to draft policies, it also regulates the appointment of various staff members within the municipality. It allows the municipality to bill consumers for charges. It sets out how budgets have to be, along with the Municipal Finance Management Act. It sets out how budgets have to be drafted, how that it allows the municipality to actually do tariffs on a yearly basis, which is what gets billed to the public. The Structures Act deals with how various structures within the municipality are governed and how they have to be set up. So how the council has to be constituted, how the mayor is appointed, all of that is set out in the Structures Act. And then the Municipal Property Rates Act deals with exactly that, property rates, and how the municipality is allowed to do general valuation roles and supplementary valuation roles, and essentially how they come up with the values of properties and hold consumers liable for property rates. So, and then in terms of those acts, the municipality also gets to draft policies and bylaws, and those then all regulate how the municipalities are to interact with the consumers.
Thank you so much for that, Micah. And now if I could just bring in Stefanie. We've just said that there are benchmarks and structures governing operations of municipal-owned entities, and specifically mentioned there was also the Companies Act. This was an avenue that OUTA followed in the national state-owned entity space. So could you tell us a little bit about the journey of the accountability team and of OUTAs into director accountability?
So good evening, everybody. A very interesting discussion. Thank you so much. So let's start. Now OUTA started with the whole entail debacle, and we know that finally entails, was done away with. After, so many supporters said, yes, we are not going to be part of this unlawful scheme. But on this journey, OUTA, realized that there's a need to challenge corruption, maladministration, etc., etc. And it was then decided that the mandate of OUTA will be expanded, and a team was built in order to hold people to account, those individuals that are wasting our taxpayers' money. Right in the beginning, just after this sort of decision was made, we were then approached by whistleblowers, very brave whistleblowers. Since Cynthia Stimple might be known to a lot of you, she currently runs, with other individuals, the Whistleblower House. She, with a lot of other individuals from SAA, approached us and, sort of shared with us the shenanigans happening at SAA. And I think I can confidently say that because of what happened during Dudu Mnyeni's tenure at SAA, and it's not just her, I think there was other factors, but I think she was one of the main players, is the reason why SAA is where it is today. And a lot of it can relate back to the actions that Dudu Mnyeni took as chairperson of the SAA board. So here is whistleblowers telling us about the BNP Capital deal. It is a deal that SAA went out on tender for, and this one specific company, BNP Capital, was then awarded this tender. And what we've realized is that, except for the fact that this tender, like with so many other tenders in government, is highly inflated, we also realized that BNP Capital did not have their FSP license. So we wrote to SAA and said, you better stop this or we will take you to court. So luckily they listened. I think they also had good lawyers on their panel, so they listened and they stopped the transaction. But lo and behold, after the contract was then cancelled, or this contract with BNP Capital cancelled, we hear that now all of a sudden BNP Capital wants a cancellation fee, something that only Dudu Mnyeni as the chairperson voted for. Everybody else voted against it. Now, luckily, that was also brought to a halt. But having all this information and, the Airbus deal, the Emirates deal, etc., we then realized that we need to do something. And if you look at delinquency as a principle, it is to declare someone a delinquent director, which means that depending on what the sort of charges are, you can either be declared a delinquent director for life or then for a period of 7 years. I'm not going to go into technicality, because if you declared 7 years, you can also go on. You can ask the court to reduce it after 3 years, and you can also be put on probation. But looking at the actions of Dudu Mnyeni specifically, we then realized that something needs to be done, and that we need to remove someone like Dudu Mnyeni you know, someone that does not take their duties as a director seriously, remove them from that board specifically, but also ensure that they do not repeat their actions in other boards. Because what we see with SOE specifically, and I think that goes for municipal entities as well, is that, you know, someone gets into trouble here, they quietly remove themselves, they resign or something, and then somewhere along the line, they pop up somewhere else and they do exactly the same. So that's when we decided, if no one else is going to do it, I think civil society needs to step in. And I think looking back, I think it's one of the best decisions we made. It was a hard journey, it was a long journey, but I think in terms of case law, it was a good thing. And hopefully that will give the strength to, you know, other groupings, other people that want to litigate in public interest, to give them sort of the basis to actually go after those delinquent directors, which, if we consider what we are discussing tonight, may apply to those municipal entities that is also wasting taxpayers' money, and that their directors do not take their duties as directors serious enough.
Thank you for that, Stefanie. One of the big things that came up specifically in OUTA's case against Dudumieni was the issue of standing. So when we talk about the structure of a municipality, we obviously know that the stakeholders involved, as Micah pointed out, are the municipal manager and the mayor and other employees, but who else would have standing in such grounds to actually bring delinquency procedures?
So when we talk about delinquency in terms of the Companies Act, I think it will always be, you know, the company itself, its shareholders, other directors, CIPC, for example, etc. But there's also a section in the Companies Act which makes it possible for what they call they make provision for other people to also bring this type of application. Now, we brought our application on the public interest, the right, you know, to do this from a public interest point of view. Now, if you look at SAA, and I think that is applicable across the board for all SOEs and then municipal entities that, you know, at the end of the day, need to act in the best interest of their shareholders, which, you know, you're more than welcome to disagree with me, but are me and you know, all South Africans are shareholders in these state-owned entities. And so we brought it on public interest. We did add SAPA, which was sort of the pilot union at that point. So if we are not successful, that they are still, you know, that the case is still able to proceed. But we were successful on the public interest. I don't think it was ever in doubt that if you look at, you know, what is happening in these entities, SOEs or on municipal level, you know, has got an effect on the public. And that I think that under normal circumstances, now every case is different and you'll have to look at all the, you know, applicable facts in that matter, but that as in general and as a whole, that you should be successful if you bring this in the public, for the public's interest.
Thanks, Stefanie. Just a note to our people who are joining us, if you have any questions, please feel free to put them in the chat. But if you see in that little panel there, there's a little blue note that says hosts and panelists. If you click that, it also says everyone. So if you want to make your comments and introductions viewable to everyone who's participating this evening, make sure that you're sending them to everyone, not just the hosts and panelists. So Stefanie, to come back to that, director accountability has a few levels. So obviously you went down the route of delinquency, and you specifically asked for delinquency for life when it comes to Dudumieni. But there are other operations there. There's internal board structures that can happen, resolutions, and different types of delinquency that can be applied. What are some of the benefits and the shortfalls of using these other mechanisms? And do you have to do all of that before you can move towards, say, a delinquency for life?
No, I think a lot of the options that are there for you in the Companies Act can be dealt with simultaneously, except for removing a director, because you can decide as a board, as a shareholder, as other directors. Shareholders can remove directors. Directors can move other directors, and that is one way of getting rid of someone, if you want to call it that. Or you can go for delinquency. Now, the only problem with delinquency, for example, is the fact that there's sort of, it prescribes after 2 years. So you can only go after a director if that person was a director 2 years prior to you bringing this application. Now, what is good news is the fact that I think people will remember that part of the recommendations from the State Capture Commission was that the legislature should look at that specifically, because if we consider our history, if we consider state capture, is that civil society specifically, but I think a lot of other individuals, entities, whoever, only really understood how big and how bad state capture was probably after 2 years of people being directors of, for example, SOEs, and that puts a damper on our ability to hold people to account in that way. So what the legislature has done, and that amendment to the Companies Act is currently being looked at the president. I hope that the people will give him a pen to sign also that piece of legislation, is to extend it to 5 years or on good cause shown. Now, there's various factors one can take into account when you decide to bring a delinquency application, but if you then can show good cause, that you are not limited by the 2 years. Now, there's pros and cons for anything that you attempt to do in law. Any application is probably going to cost you a few bucks. With the delinquency application specifically, we decided to go on the action route, which just means we serve the summons, and you are allowed to call witnesses. The minute you go that route, you can imagine you need to make sure your witnesses are there. It is costly. I think, as a legal representative or someone in the legal field, I can say that, we talk about legal people charging like wounded buffalo. So it is expensive. You can go the application route, which, is a shorter, it's on paper, it's on affidavit, which may save you a few bucks. So it is not a process that, you thought about one day and the next day it's done. But I think what we need to start realizing is that, and this is where business also plays an enormous role, is that, yes, it's easy to say, no longer my problem, person is no longer part of my board, let's move on. But I think it is our duty to make sure that people do not repeat their behavior. And specifically when it comes to state-owned entities, municipal entities, et cetera, we need to stop this thing of, people getting away. That being said, we must also remember that there's quite a few other sections in the Companies Act, your criminal, in terms of, criminal complaints that you can lodge. So if you want to sit and hold someone to account, and I'm not saying that it's easy, but you can, for example, lay a criminal complaint and hold someone, bring an application to declare someone a delinquent director. So you're not, you don't have to go down one avenue, and laying a criminal complaint, for example, is not going to cost you an enormous amount of money. But we all know where the NPA is finding themselves. So, the wheels of justice are turning. I'm still confident that it's turning. It's just sometimes turning a bit slowly and sometimes it's moving backwards, but they're getting there. But one should consider that even the Companies Act and your municipal, Municipal Finance Act, et cetera, there are some penalty clauses, and some of them you can really do simultaneously. You don't have to do the one and then the other one.
Thanks, Stefanie. I just want to note two things that have come up in the chat from Jackie in the Clarence Ratepayers Association. They're currently having problems with the Dilliking Municipal Water Manager regarding the Lesotho Highland Tunnel closure, which is going to happen for 6 months over October. We as WaterCAN and JoburgCAN are particularly following this process. We do highly recommend that these systems are shut down because maintenance is a vital part of all of these asset structures. And that is what is going to be happening in those 6 months. We've been told that there are plans in place to be able to provide water during this time, and that there are contingencies, but we are actively following that up. I don't believe that a PIRE is necessary at this point to make sure that those contingencies are in place, specifically, Jackie. But as we follow that process, and we particularly bring it to the Water Forum, where Joburg Water, Rand Water, City of Joburg, and civil society, as well as the Water Crisis Committee sit, we're discussing that plan. And if nothing comes of that, we will be sure to keep you updated. You'll also note that next month, our workshop is hosted by WaterCAN, and any questions regarding that will probably be answered in that session. I'd also like to acknowledge a specific question about how civil society can hold executive directors in a municipality responsible, as the electricity department is incurring electricity losses in excess of 26%, running to hundreds of millions of rands, and it's increasing. This is from Dion Folionen, who I believe is in eThekwini. They already have a warning from the AG. So I'd like to understand, when it comes to the financial losses that we're seeing within municipalities, what are the suggestions for like going up against an entity that's both a service provider but also a municipal owned entity? And what recourse do residents have when it comes to them not actually filing their financial duties? Micah, you specifically mentioned that there's issues with their audited reports. What do we do when basically they are collecting tariffs but not enough, they're not collecting everything, and then the systems are breaking down? So when we're seeing these huge losses, and there's no specific business plan to turn it around, is a delinquency possible in that kind of situation?
I'm not sure. I'll address some of it, and then Mike can come in and maybe just add on to what I'm saying. If a municipal entity is, and I don't know how else to explain it, is a private company. In other words, the municipality has decided to take over a private company, and in terms of the Companies Act, it is a private company. Then you have a board, and the Companies Act is applicable. When you have just an agreement with some type of entity, and there's that will not, then unfortunately you can't bring a delinquency application. A delinquency application is specifically for directors that is negligent in their duties. Now, I don't think, delinquency, whether it is an SOE or whether it's a municipal entity, it is about the reckless actions of your directors. And as we have seen with the Dudu delinquency application, although they are as a whole responsible, each and every one of them as an individual is also responsible. So in Dudu Manyeni's case, in order to just maybe explain that, is you understand that there was more than one board member. Why did OUTA only go after the chairperson? Now, except for the fact that the specific facts that we had, and the two charges that at the end, was the reason why she was declared a delinquent director for life, was the Airbus and the Emirates, and she was directly involved. And we didn't have the funds to go after the whole of the board. It was, to begin with, not really our duty. But so we chose the chairperson, because the chairperson, you must understand, even in terms of King 4, that has got his, they're responsible for sort of the ethics that goes around in a board. So that's why we've decided. And it may seem like a daunting task to go after all the board members, but I would look at the facts and what you can prove. And in most instances, there's probably one or two fraught apples that are standing out, and that you may look at maybe going after those individuals if you want to declare them a delinquent director. And, support in that in that instance, you know, we're not necessarily talking financial or whatever, but just support. I think you will get from you know, a lot of other ratepayers associations, civil activist organizations like OUTA, etc., because it is very important. We need to start a movement so that the people that put their hands up to sit on boards take that duty extremely serious, because currently it seems that we have political you know, deployment. Some of them I do not think has got the knowledge to sit on boards to know exactly what's happening, and they just get away with it, because if you know, something doesn't pan out on the one board, they just move to the next. And even more so in municipal entities, because if you think about it, Joburg, for example, all they do is they, you know, sort of outsource some of their services to these entities, who are then, for all practical purposes, the municipality, who are supposed to, you know, give us the services we deserve, because we pay for that in terms of taxes. And that if you are going to run a municipal entity into the ground so that it does not give you know, the people the service that they deserve, that delinquency is one of those tools in your you know, tool shed that you can use in order to hold them to account. And we must start somewhere. So that's just my 10 cents. I don't know if Micah wants to jump in.
Thanks so much, Stefanie. So look, the biggest problem that we've come across in holding directors in these MOEs liable for anything is the proof, is actually finding substantial proof to show that someone or someones in the, you know, in these MOEs actually did something concrete to cause the losses or whatever. So we haven't actually been able to bring a delinquency application like this against anyone because the proof isn't there. And you can, you know, obviously ask for all of these documents to be made available to you, but believe me, trying to get documents out of a municipality is like pulling all of your teeth without any kind of pain medication. To put it as nicely as I can. So it is definitely possible with the MOEs to bring a delinquency application, but it's going to be very difficult to do so because you won't necessarily have the proof to show that a specific person or persons are the ones that are responsible for the losses that are being suffered. So that is unfortunately part of the challenge that we face.
So to kind of dive into that a little bit more, and specifically to kind of go into a few points that are being made in the comments. In these workshops, we've previously discussed how to raise a dispute with the municipality. So if your bill is wrong and you don't know what to do about it, these are the steps you can take. We kind of ended off that discussion by saying that you could escalate the highest point to the city ombuds. But during that session and subsequently, Micah, I know you get this a lot, specifically at Schindler's. There's a lot of feedback that even when you go through every step diligently, you can still get cut off. You can still run up huge disputed interest rate charges and spend years trying to resolve issues. So using the city of Johannesburg as an example, we've had some high-profile media reports recently, such as the arrest warrant being issued for the municipal manager in his personal capacity. And that was particularly around a billing dispute and a contempt of court order that was brought. So the question is, where does the buck stop with municipal directors such as at Joburg Water or City Power, as well as people who are not necessarily directors? They are people like the municipal manager or the head of a department like development planning. Can they also be held liable for failures like the unfolding water crisis in the city personally?
Thank you, Julia. So yes, they can be held liable in their personal capacities. Absolutely, that is a possibility. The problem is just, like I said earlier, the level of proof that you would need to show that that person is directly and personally responsible for the failures that you are holding them accountable for. With a municipal manager, it's a little bit easier because he has this overarching absolute accountability with regard to everything. So anything that doesn't happen, with, let's say, a municipal billing dispute is overarchingly his fault, and he is accountable for it, even if he had no even if he didn't necessarily have the personal knowledge in that regard. But with the directors, you would need to, have a causa. So you would have to have a link between what you're accusing them of and what is happening. So if there's like you said with the water failing, that you could probably link to them, but you would need to have sufficient evidence in order to make that specific link in order to hold them accountable. So like with the example that Stefanie gave, there was very, very clear evidence that there was failings in SAA, and they were able to hold the chairperson liable for that, but they had the necessary evidence. So that is always the biggest question, is whether or not you would be able to hold that person personally liable because you need to have that necessary proof. So one of the mechanisms that we've been finding very, very helpful of late is to actually, in our court applications, ask for the court to hold either the legal manager or whoever the person that we're dealing with. I'm going to give you an example. In just again for City of Joburg, they've recently started this new trend where they like to issue fines for purported water meter tampering. And they just come to the property and they hand you a notice and they say to you, here, there's a 500,000 rand fine because you tampered with the water meter. And in most instances, there hasn't been any tampering, or the city itself did something to the meter and is now holding the property owner liable for it. And we are bringing promotion applications in terms of the Promotion of Administrative Action Act to review the decisions of the municipality, and specifically of Joburg Water, as to who came up with the idea to hold them liable for this fine. What were the reasons for this decision? So we're basically going on a fishing expedition to try and get all of that information from the city. And then once we have that information, the second part of the court application is that we are asking for the court to hold that person personally liable for all of the legal costs and the damages that were suffered by the property due to the lack of, because of when they come and deliver the notice, they also disconnect the services. So we also ask then for damages claim against that person in their personal capacity for the damages suffered by the property because they didn't have water. So in most instances, we're talking about huge body corporates or huge businesses. Seems to be the target at the moment. And those businesses or body corporates then have to come up with alternative means to get their, give their residents or their business water in order for the business to run or for their residents to live. So we're holding them liable in their personal capacities for those charges, for the legal fees that we are incurring in bringing these court applications, and for the damages that were suffered. So there are creative ways to come up with this, and we're really finding that these applications to hold someone personally liable for legal costs is hitting home, because then it's not, the municipal employees aren't just playing with municipal money anymore, they're playing with their own money. And then you'll see how very quickly people come to attention. I'm not sure if you guys are aware, but there was a judgment that was handed down in the South Gauteng High Court not too long ago. I think it was about a month ago now, by Deputy Judge President Sutherland. And it was a very, very scathing judgment against the municipality, its attorneys, and the legal advisors at the city, because the city was essentially doing everything in its power to drag out the court proceedings and was just not coming to the party and not delivering documents. And the matter was basically ripe to proceed, but the city failed to file its heads of argument, which in the motion proceeding is the last step that needs to happen before you could apply for a date. It's changed a little bit now, but at the time this was the way that things were done. And Sutherland essentially said to the city that the legal advisor needs to come back to court and please and explain why the affidavits that he filed are all just for the purposes of delaying the matter, and said to the city's attorneys of record that they aren't allowed to charge the city for any of the legal fees that they have incurred in dealing with this matter, and they held the city as well as the attorneys liable for the legal costs of the court application up until that time, and struck out the city's defense and basically gave them no opportunity to defend the matter whatsoever. So the courts are becoming very much alive to the situation as well. So it's becoming more and more prevalent that everyone is becoming aware of how terrible the municipalities are, even in legal proceedings, how they treat the people that try and seek relief from them. So there are definitely ways and means to do this. I would just suggest that every case has its own merits and own facts. So, if you speak to a legal professional that has experience in this, they should be able to come up with a creative way to get you your personal responsibility of those people, even if it isn't through a delinquency application.
Thanks for that. So I specifically want to dive down into something that recently happened in the news. And this is, of course, the tragic Marshalltown fire that resulted in the death of 77 people. And the first part of that inquiry that's being released in two parts. The first was to find liability. And they found that the municipal-owned entity, the Johannesburg Property Company, should be held liable, and disciplinary action should be taken against the relevant officials, both of the city, the JPC, and other bodies who contravened their duties and failed to act despite knowing the conditions of the building. Of course, on a national level, we've had the Zondo Commission and the State Capture Report. And with that, what we're seeing is that there are strong recommendations for the holding of the state entity directors to account. So what happens in the case of the JPC when reports like this come out? When we're told these people have to be held liable, who's supposed to do that? And is that being done? Because as far as we can see, no one's in jail when it comes to the State Capture Report.
Ask me, is that is the problem we are facing. And I think that is the problem on, not just with SOEs on a national level, but on province and local government level. Is that I feel that the municipality, whose duty it is to look after the property company, they are ultimately the accounting officer, and must ensure that their company does what it's supposed to do. So firstly, I would say that a municipality should hold their company to account. They should remove the directors because they can. They should possibly think about bringing delinquency applications if there is a case to be made. And, the disciplinary actions, I mean, it is up to and that goes again for national, provincial, and local government, is that it's normally the government that must hold to account the people in certain positions. But now we can go into a whole long discussion because of the political interference, because there's no political will in order to hold these people to account. Probably nothing happens. And this is where the question, like, then who should? Now, maybe this is something that one should consider, is that in the event that the municipality doesn't want to hold to account, the directors of their company, is that one should not consider, if you don't have enough evidence to make out a case, to force the municipality to hold their companies to account. Because for the life of me, I mean, if you are in, if you have a company, you are a shareholder, or you are a director and you have a CEO, because it's about reputational risk, it's about how much profit you make, that you will make sure that you have the best people in the positions in order to take your company forward. And that's a problem we sit with in municipalities, is that people are in positions earning an enormous amount of salary. I saw somewhere, I think, a question about, the salary structures. It is out of hand. Recently, I've heard, and I think if you put your ear to the ground, is that the administrator of NSFAS is earning more than 7 million rand per annum. To do what? So we are really sitting in with this debacle that the state salary bill is just out of hand, and that goes for municipal managers. Because don't you think that would be a lovely position to sit in if you earn an enormous amount of money? You don't really have to worry about services to the people, because you know what, you actually don't have money, because after a municipality paid all the salaries, there's nothing left for services. Actually, you know what, you are also expected just to pay, and nothing will happen to me, because politically there's no will, and to go after these individuals. And so it is it is time that one thinks outside the box in order to hold these people to account, because I refuse to believe that if the institution, local government, a municipality is not going to do it themselves, that is where civil society has got a duty to see if they cannot, help the process along of getting rid of the people that is really just there for their paycheck.
So another point here, of course, these people earning these massive salaries are not necessarily always the best people for the job. So we're looking at situations where the competency of these boards and directors is put into question. So how do we make sure that these entities aren't captured, the cadre deployment is not degrading these entities, and the people holding these positions are actually qualified to run them, and therefore ensure that the directors and boards and the MOEs are fit? So Stefanie, perhaps you could take us through the requirements of directors for SOEs. And then Micah, are there any specific requirements and qualifications or experience that you have to have a position like a municipal manager?
So in terms of a director, I think that's across the board. So you have general principles in terms of, Section 76 of the Companies Act that specifically makes provision for the standards of directors' conduct. And then also, in terms of the MFMA, if that is applicable when it comes to municipal managers, et cetera, et cetera. So it is not a closed list. There's Scheme 4. I know that some of the sections in the Companies Act is not necessarily applicable on SOEs, but I think what is standing above water is the fact that the standard for a director is sort of the same across the board, whether you are in the public sphere, whether you are in the private space. Now, a director cannot use his position to obtain information, to his benefit while he's being a director. So this speaks to, a director of a municipality's entity who uses the fact that he's a director to get some tender for a friend or whatever. That is, grounds, for example, for delinquency, and that makes you a bad director. You must act in good faith and for a proper purpose. Best interest of the company, which, what does that tell you? Best interest of the company that belongs to a municipality means that you need to act in the best interest of the people. And you must have a degree of care, skill, and diligence that is reasonably expected of you as a person in your position, and then having the general knowledge, skill, and experience of a director. So under certain circumstances, if you look at the very emotive NHI bill that was just signed, and we can have I think 3 webinars just on that. If you look at what is expected of a director, there's specific, for example, standards that a director must abide by. And if a director doesn't fulfill that, the director should be removed and not appointed. But again, this is the level of the problems, one should start attacking, because normally, and specifically in state-owned entities, it's the minister that appoints the director. So there is, I think one should do more advocacy around the fact that civil society should be more involved in appointing, directors to these positions. But what is so sad is that if you look at the law, if you, for example, want to be a director and you want to take the responsibility of being a director of, for example, a diamond company, you can't claim that I know nothing about diamonds and therefore I cannot be held liable. As a director, You can only say yes if you will take the responsibility of acting with good faith, etc., etc. So firstly, there's in terms of the Companies Act and legislative, I believe that there's added burdens on directors if something specifically is required of them. And then, you know, policy like King 4, although King 4 is not always applicable on all types of companies, I think it gives you an idea of how a director should act. And I think that there shouldn't be a difference between, you know, national SOEs, you know, big ones like Sunroll and SAA versus a municipal entity. The principles are exactly the same. And we can have a debate about where is the most damage being done. I think, you know, there will be competition. And, you know, our eye is always on national, because SAA bailouts, you know, that's our pockets, because every time government needs to bail out a big SOE, that means that there's less taxes to use for other things like education, etc. But the same goes for municipalities. Where do you think the money for municipalities come from? It is from the fiscus. I mean, you know, with the whole entail debacle, when they said that, you know, Gauteng will pay some of the debt, and where does Gauteng get 80% of their budget? From national government. It sounds like a money laundering scheme. You know, we're just going to replace funds. At the end, it comes out of the fiscus, which is fed by, you know, taxes. Each and every South African in this country that, you know, buys something is a taxpayer.
Thank you. Micah, do you have anything to add?
Yes, thanks. So yes, there are specific requirements for a municipal manager at least to be appointed, and for some of the other heads within the municipalities. So the Municipal Systems Act was actually quite recently, and by recently I mean 2022, was amended to bring into legislation that there have to be specific requirements for a municipal manager, and if he doesn't meet those requirements, interestingly enough, his appointment as such a municipal manager would be void ab initio. So which in layman's terms means that the entire fact that he was appointed would just be non-existent and wouldn't be allowable from the moment that he was appointed. So in terms of the regulations that were brought into effect in relation to this amendment to the Municipal Systems Act, a municipal manager has to have a bachelor's degree in either public administration, political sciences, social sciences, or law, or an equivalent. And then has to have at least 5 years of experience as a senior manager, and has to have proven successfully that he has an institutional transformation knowledge within the public or private sphere. So those are really the only requirements that are put in place for a municipal manager. He has to have certain competencies as well. There's a whole long list of them in the regulations. But the core competencies that are expected is that he has to be morally competent, he has to be able to plan and organize, analyze and innovate, must have knowledge and information management skills, must be able to communicate, and be results and quality focused. So considering how important this role is in the overarching functionality of a municipality, it's actually a little bit scary that it is so that so little is set out in relation to his or her requirements to be appointed as a municipal manager.
And definitely some oversight into their key performance indexes needs to happen in a much more public way, in our opinion. So I'm going to dive into some of the questions here, and I'm sorry we're running a little bit over because this is obviously a very technical element to be discussing. So please, we encourage you to try and stay on as much as possible, and I'll get through as much of what has happened in the chat as we can. But something that particularly came up, and it's a personal bugbear of mine, so I'd like a little bit of input on this. When it comes to the contracts and tenders awarded in this space, And it's come up in the Auditor General's reports and feedback on a lot of the annual reports of these different municipalities, that a contract is handed out. There is no oversight as to whether or not the contractor runs out of money, whether the contract has been fulfilled to the requirements, if there's insurance on these structures, all of that kind of thing happens. So when we have a contractor who's been given a tender to supply and do work within the municipality, what oversight can we push for there, and what accountability can we push for when it comes to both employees and directors in these companies? So for instance, what happens for instance to the CEO of the JRA if there's been an overrun on a project with a road project? Sorry. And then also a specific question on when these things have happened, when there's been a tender awarded. If a development is approved and the person who approves it doesn't have the actual qualifications to hold their position, can that approval be made void?
Hi. So the first question was about these tenders. Now, it so depends on the facts of each matter, but in theory, you can go after the CEO, you can go after the board of the private company, you can go after the municipal manager, you can go after whoever you can prove a case against. And unfortunately, that's normally where the problem lies, is the fact that, you know, who do you hold to account, because who can you prove did the actual thing? You know, asking for damages in terms of your Companies Act, you can go after directors if you can prove the damages. So I think in general, the problem is although there are avenues available, and I saw that comment as well, is that, you know, legally you can do a lot. You can actually want to say you can do whatever you want, but you have to consider that it is expensive. And in some instances, it can really be very expensive. But that cannot be the only avenue. And this is where I think active citizenry, what I think we're trying to bring across with JoburgCAN, is get involved. Because the more you get involved, the more you know, and the more facts you have, you know, the more you can do. And with those facts is to try and, you know, I want to say use it against them in order to make sure that services are rendered in the best interest of everybody. Now, when it comes to tenders, you can ask for the tender to be set aside. Normally, you know, from experience, sometimes other companies that tendered, that has got inside info as to, you know, stages and whatever, you can ask that decision be reviewed and say that it was an irrational decision to a point. But it is all about, you know, proving that. So what I want to say is, although you don't always have to do this legally, it is important, and it is going to take some energy in order to, you know, get together the facts, because the more facts you have, the more you can push back. But just pure mobilization, make it extremely difficult for people to, you know, to do business. I mean, if they, and this is where companies has got also a job to do, is that, you know, what about a blacklist of companies that are doing business with government but never fulfill, you know, what they are supposed to do? But business normally say, not my problem, not going to get involved, and they're doing business with government, so they don't want to upset the apple cart. Get involved in your IDPs, in your local community. Most probably, you know, there's a lot of problems in terms of local government. We will not solve all of them tomorrow, but that does not mean that we should start now digging, do the investigations, and whistleblowers. I mean, we were very lucky with whistleblowers in Dudu Mnyeni's case, and that we got all the paperwork. But it is also to advocate for people to stand up and be brave in order to tackle all these things. I make it sound, but it is. I think if you believe you can, you will be able to, and you'll find a way. Sorry, Julia, I forgot about the second question. So that's my 10 cents about holding people to account. I know people are a bit, don't really want to do criminal complaints, but that ideally should also be an avenue, and private prosecutions. I mean, we were thinking about at some point about private prosecution. So if you can get the NPA to say, okay, here's a knowledge certificate, that you can go after these individuals, and specifically environmental affairs, it's, a little bit easier to do private prosecutions. But what I'm saying is that unfortunately it is effort. But I do think, maybe this is just my final word on the issue, is that if you start making the kitchen too hot for the cooks to be in, maybe the cooks will understand that they need to cook the food that is to the satisfaction of their customers. If we keep on complaining, then, they are just going to get away with it, literally getting away with murder. And I think it is up to us as active citizens to make it impossible for them to get away with these things. Sorry, Julia, I can't remember the second question.
No problem. Perhaps, Mikey, you can answer it. It's basically if the person who awarded a tender or a subcontract doesn't have the qualifications to actually hold their job, can the things that they're approving and putting out actually be made void?
You can, but again, you would need to have the proof to show that they don't have the necessary qualifications, and you would need to then review the decision of the tender being awarded to that company, and then you could have it declared void from the get-go, and then the company would have to obviously return any funds that they had received from the tender giver in that regard.
Yeah, and this blacklist of organizations, I think, is something that we really need to be pushing for, specifically as civil society. So I've got two lawyers in the room. So let's specifically talk about the cost of these kind of matters. So obviously we're seeing that one of the best avenues at this point is legal recourse. That costs a lot of money. And there's a specific clause that's being used against civil society and groups that are coming to the courts with these issues, and that's cost orders being attached. So how do we prevent that kind of thing? And let's have a real honest conversation a little bit about, whether or not what we're talking about is feasible for a lot of residents associations and groups, because the cost of legal matters is really punishing.
Yeah, costs. It is expensive. It's one of those things, because it is a process and it's civil procedure. And someone, I think, asked, what's the difference between the criminal and delinquency? It is your burden of proof. Criminal is always a bigger burden because you can understand that someone can go to jail. So it is, but in civil matters, which delinquency is, it's on the balance of probability. So it is maybe easier to do delinquency than it is criminal. But, the minute you deal with civil procedure, it is going to be costly, but it doesn't have to, I think, break the bank. If you are confident about your matter and you go about it the right way, there are ways of either, minimizing your costs beforehand or then get your costs back. We are currently, we got a nice cost order against Dudu. In fact, I think we've got some punitive costs because she just went out of her way to make this as impossible as possible, in order to get her to court, get her to interlocutory application after another. But at the end, we got a cost order. Now, we executed against her. In other words, she didn't pay our funds, so we tried to get the money back. We are now busy on a different route because we are simply not getting our money back. So it's something you need to you need to consider. But if you ask me, was the delinquency application worthwhile? Absolutely. I think as OUTA, we will do it again tomorrow, because the positive outcome out of that was tremendous. And I hope we can continue that, even if it's just to say, if OUTA can do it, so can you. And that at the end of the day, anything worth fighting for is worth fighting for. So that's point number one. The contentious issue is the buy-watch rule, which as of late seems that courts, use that against civil society, and it shouldn't be. I think the principle is they are, unfortunately, there's always exception to the rules. There are, I suppose, civil activist organizations or organizations, whatever, out there that, just bring legal cases for the sake of bringing legal cases, and they should be punished for that. But that, again, that is about advocacy. That is about civil society standing up. And if you get in the court order that's against you, is to work, and specifically in the civil society space, is we try to support one another. We had a whole, meeting about the buy-watch rule, what these organizations are going to through, and to support one another, and to make it, and to create a public debate about, is that in the best interest of whatever civil society is fighting for? 3 pillars were our saving grace when it came to state capture. And that was civil society, that's all of us, normal citizens, media, journalists, that was, freedom of speech, that was able to expose these things, and then an independent judiciary. So in that, everyone here tonight, and everyone out there, have an extremely important role to play in exposing corruption, maladministration, and we see a lot of maladministration on the level of municipalities. But okay, that's my 10 cents. Micah?
Julia, Stefanie, I completely agree with you that at the end of the day, it is completely worth it to, I don't know if you guys remember, there was a movie a couple of years ago called The School of Rock, and the teacher that was the music teacher, he used to always say, stick it to the man. And that's kind of my policy in life is I like to stick it to the man and get, justice for people. So yes, unfortunately, litigating against anyone can be very, very costly, and it can be incredibly frustrating because you feel like you're already having to pay for the services that you maybe don't receive. And then you, on top of that, now have to actually litigate against the people that are supposed to be providing these services. To answer your question, Julia, about how much it costs, that's like asking me how long an endless piece of string is. I can't tell you that in advance because every single matter is different. Some matters are very simple and can be, relatively affordable. Other cases can be incredibly complicated and it can be very, very expensive. It just depends on the kind of matter that you're looking to bring. There is no, hard and fast rule with regard to these costs. But what I can say, and what we're trying to advocate for now, is for groups to band together. So we do almost class actions without it being class actions, where we get a whole bunch of property owners with the same kind of issue to band together and to have, deal with their matter in one go. Excuse me. So that way, between all of the property owners, they can share the costs and they also share the risks. So that if you were to get a cost order against you in the event that you were unsuccessful, then you at least not, in for those costs on your own. So that is also an option to look at, is if you have a matter that there's multiple other people that are sitting in the same boat as you, that you band together and you share the risk and you share the costs, because that's, community outreach is a great way to do that. We've actually got about 10 or 11 applications like that running at the moment, where there's in excess of 20 applicants in each of the applications, so that they can share the risks and share the costs, and it's working very well thus far. So I hope that answers your question over and above what Stefanie has said.
Thank you. So something also that came up in the chat, where exactly does SALGA and COCTA come into this debate? Like, where do they stand when it comes to actually forcing accountability in municipal structures?
Who's SALGA and what are they doing? That's the problem, is that they have a job to do, but I think that they're also missing in action, that I don't know if one has to, cry about it or laugh about it. You see, and this is about leadership. I don't think that the legislature, the drafters of our constitution envisage the position we are currently in the sense that what we need is leadership, and what we need is ethical leadership, and that there is accountability. I don't think the legislature envisaged the fact that you have to have penalty clause for everything someone needs to do, because lo and behold, they don't do it. We do not expect that people in certain positions will not do what is expected of them. And unfortunately, that is where we find ourselves. So that is where bodies like Salga, Kulili George, that was, CEO of Salga, earned also a salary of in excess of 4 million rand per year. And you wonder what he did for that if municipalities are in the mess that it is currently. And then he went to Parliament. He was supposed to get 2 million. Now he gets 4 million again with all the perks. It is just ridiculous. But I think it boils down to that, when we go to the ballot, when we go to our voting stations on the 29th, it's very important. Everybody, please, we need to go vote, because then we will affect change. We need to change the political will in order to affect change. And I think it is for civil society to stand up and say, we have the power. We really do. We just need to start using it, and start using it in creative ways. It doesn't always mean that you need to go trash something to get your voice across, but you have a voice, and we need to change it ASAP.
Thanks, Stefanie. So I also just want to point out something particular that's happening in the chat, and that is when we talk about this is your money, we're not just talking about people who pay income tax when it comes to bailouts of different entities. This is, you pay VAT, therefore you have a stake in this. If we're talking about ratepayers and you pay your rates towards the city, we're also talking about tariffs. So anyone who has ever bought prepaid electricity or consumed water and had to pay a bill, this includes you. So we all have a major stake, no matter how we own our houses, no matter what property we own. This is something that we all can participate in. And this is something that I think is really important, that we start holding these people accountable. We have a platform, can.org.za and JoburgCAN.org.za, where you can find a lot of this information. We put together a pack after every one of these workshops to lay out the different things that we've discussed. So there you will find Stefanie's great paper on directed delinquency. You will also find information about the structures of the different municipalities and how they work. We are specifically pushing for a more oversight into what's actually on these municipal websites. So if you go to your municipality's website, what should you be able to find there? And that includes these organograms and exactly who's responsible for each one of these departments, because in some cases, they haven't been updated for about 4 or 5 years, which is incredibly annoying. And I know I've been trying to find out who the current acting of this and acting of that is, and it's very frustrating. So that's a little bit of accountability that we're trying to provide as JoburgCAN. So throughout the series, we've learned about tools and mechanisms to be active citizens. And what we're finding, and specifically tonight, it's not a quick fix and it's not a cheap one. Time, money, political will are all needed to get action. And the case studies we discuss are definitely not a one-size-fits-all response. But I think what we've heard today about the successes at a national level and some of the legislation that is happening and the different departments that we might want to start investigating as civil society is a place to start. So that's what these workshops are supposed to do. They're supposed to spark debate. They're supposed to get you to kind of think outside of the box about different ways that we can apply accountability to different mechanisms from the national to the local government sphere. So as we kind of get into these conversations, we discuss things a little bit more. We'll also have a discussion about the development planning structures and how all of those kind of things work later on in the year. And then we'll kind of get to the nitty-gritty of, so what have we learned and how do we intend to apply it? And how do we encourage different civil society organizations, ratepayers organizations, and so forth, to take up this mantle and start fighting these different things that we've kind of picked at and gone, well, this organization have done this municipality have done that, and start giving you a roadmap for different types of activities that might be a good way to apply accountability. So that's definitely what we're trying to do here, and we hope tonight has been useful. Next month, like I mentioned earlier, is a workshop series by the WaterCAN team, who in Youth Month will be discussing the role of youth in water stewardship. So I highly encourage you to join. And if you want to join the CAN network or find out more about what we do, please check out can.org.za. This has been the third in our CAN workshop series. Please let us know what types of topics or questions you would like us to tackle in these monthly workshops. And if you still have questions after tonight's session, please also go to the CAN forum, where you can engage with each other and ask questions, and please register and continue this conversation on the forum, and you can get a little bit more information. If you still have any questions, please feel free to message us directly at can.org.za. And I'm Julia Fish, and I'd like to personally thank Stefanie and Micah and the entire team at OUTA for all of the work that goes into these sessions. We really appreciate your time, and we're definitely going to start making these sessions 90 minutes long, because there's so much to unpack. From me, Julia Fish, and the entire local government team at OUTA, thank you and good night.